He looked me dead in the eyes, smoothed the front of his jacket with both hands like he was preparing to accept an award, and said, "Your Honor, with all due respect, you are powerless to stop what's already been set in motion." The courtroom went so quiet I could hear my own heartbeat. A woman in the second row of the gallery pressed her hand to her lips. The court reporter's fingers froze above her keys. Two jurors, who should not have been present but was still filing out after I'd asked for a brief recess, turned their heads slowly toward the defense table like they couldn't believe what they just heard either. I set my pen down. I folded my hands on the bench in front of me. I did not raise my voice. I did not blink. I looked at Marcus Del Rey Cole for a long, steady moment, and then I said, "Counselor, I want you to remember exactly what you just said, because in about 60 seconds, this courtroom is going to become a very different place for you." He smiled, slight, controlled, the smile of a man who has never lost and doesn't believe today will be any different. He would not be smiling for much longer. My name is not important to this story. What is important is that I have served as a sitting judge in the 11th Circuit Court of Hadley County for 22 years. I have presided over hundreds of cases. I have watched brilliant attorneys argue. I have watched desperate defendants lie. I have watched witnesses crumble, juries deliberate, and verdicts change lives in both directions. I have seen arrogance walk through those double doors in every form it comes in. The quiet kind, the loud kind, the kind that wears an expensive watch and speaks in perfect paragraphs. But in 22 years, not one person had ever stood in my courtroom and called me powerless, until Marcus Del Rey Cole. To understand what happened that morning, you have to go back 14 months earlier. You have to go back to a suburb called Ellendale, to a modest split-level house on Creston Drive, and to a woman named Patricia Huang, who was sitting at her kitchen table at 11 o'clock at night, staring at a bank statement that made no sense. Patricia had built her catering company from nothing. She called it Peach and Pepper, and for 7 years it had grown steadily and quietly the way honest work grows, slowly, sometimes painfully, but with real roots. She had started with a single folding table at a church fundraiser, making her grandmother's recipes from memory, charging $15 a head, and going home with blisters on her feet and a smile on her face. By the time the trouble started, Peach and Pepper had 6 full-time employees, contracts with 3 local event venues, and a reputation in the community that Patricia had spent nearly a decade building, one satisfied client at a time. She was not wealthy, but she had built something real, something hers. The trouble had a name, Gerald Ashworth. Gerald had come into Patricia's life through a mutual business contact at a regional food industry mixer. He was polished, well-spoken, and he came with what appeared to be impeccable credentials. He had a professional website with client testimonials, a portfolio of past partnerships, and a smooth, reassuring manner that made you feel like you were the lucky one for having met him. He told Patricia that he represented a group of investors who were specifically looking to back quality local food businesses with growth potential. He said Peach and Pepper was exactly the kind of operation they were looking for. He said within a year, with his connections and her talent, she could be catering corporate events, hotel conferences, and regional galas. Patricia's attorney at the time was a general practice lawyer who mainly handled residential real estate transactions. He reviewed the partnership agreement Gerald presented and said it appeared standard. Patricia asked him twice if she should be concerned about anything. He said no, both times. She signed. What happened over the next 8 months was methodical and devastating. Gerald moved $46,000 out of the joint business account in increments small enough to avoid triggering automatic review flags. He signed vendor contracts in the company's name, contracts Patricia had never seen and never approved that locked peach and pepper into agreements with suppliers Gerald had personal relationships with at rates well above market value. He redirected payment from two of their largest venue clients into a separate account that only he could access, telling Patricia the funds were being held temporarily while some administrative matter was sorted out. When Patricia finally demanded a full accounting and sat across from Gerald at a conference table with her new accountant beside her, Gerald looked at the numbers, looked at Patricia, and said, "You should have read the fine print." Patricia went to the police that same afternoon. The detective she spoke with referred her to the district attorney's office. The DA's office opened an investigation, and within 60 days, they had enough to charge Gerald Ashworth with 2 counts of fraud, 1 count of breach of fiduciary duty, and 1 count of criminal misappropriation of business funds. The evidence was documented. The paper trail was clean. The emails were preserved. The bank records told a story that was difficult to argue with. What Patricia did not know, what none of us in that courtroom fully understood until it was almost too late, was the kind of attorney Gerald Ashworth had hired. Marcus Del Rey Cole had been practicing law for 19 years. He had built his career on high-stakes defense cases, the kind that other attorneys quietly declined because the odds were too long or the facts were too bad. Marcus took those cases, and he won most of them. He had secured an acquittal for a contractor facing insurance fraud charges by spending 3 full days in front of a jury deconstructing a single subordinate clause in a policy document. He had walked a real estate developer out of a money laundering charge by surfacing a conflict of interest so technical and so obscure that even the attorneys in the room were still processing it when the jury returned a not guilty verdict. He was, by any honest measure, exceptional at what he did. He also believed with every fiber of his being that he was the smartest person in any room he entered, including mine. The morning the trial began, Marcus Cole arrived 7 minutes late, not because of traffic, not because of a scheduling conflict. He arrived late because he had calculated that arriving late would signal to everyone in the room that his time was worth more than theirs. He set his briefcase on the defense table, the way you set something down when you want people to notice the weight of it. He looked around my courtroom slowly, taking it in, and then he sat down and crossed one leg over the other, like a man settling into his favorite chair. I noted the 7 minutes. I said nothing, but I noted it. The prosecution was led by Assistant District Attorney Renee Voss. Renee was 34, methodical, and deeply prepared. She was not the kind of attorney who performed for galleries or played to cameras. She built cases the way you build a brick wall, one solid piece at a time, mortared carefully so nothing shifts. She had spent months with this case. She knew every transaction, every date, every account number. And she had a forensic accountant named Dr. Calvin Breaux, whose testimony was so precise and so clearly organized that it was almost difficult to look away from. Marcus Cole's opening statement lasted 41 minutes. He told the jury that Patricia Huang was a businesswoman who had made a series of poor decisions and was now seeking a criminal remedy for what was, at its core, a civil dispute between partners who disagreed. He said Gerald Ashworth had operated entirely within the scope of the agreement both parties had willingly signed. He said this case was about wounded pride and misplaced blame, not criminal conduct. He said it with total command and complete composure, and I watched 2 jurors in the back row nodding along before he had even reached his conclusion. He was good. I had known he would be good, but watching it in person was something different. The first 2 days of testimony proceeded as Renee had structured them. Dr. Breaux took the stand and delivered his financial analysis with the calm clarity of a man who had done this many times and felt no need to rush. He explained every transaction in plain language without oversimplifying it, and he connected each one directly to either Gerald's personal benefit or to a decision Gerald had made without Patricia's knowledge or consent. When Marcus cross-examined him, he did so aggressively and at great length, attacking the methodology, questioning the sourcing of certain figures, and suggesting repeatedly that an equally qualified expert might reach entirely different conclusions. Dr. Bro did not flinch once. He answered every question directly and completely. When Marcus finally sat down after nearly 4 hours, the jury looked slightly exhausted, but the evidence had not moved. Then Patricia took the stand. She was nervous. It was visible. Her hands clasped together in her lap, her voice too soft at first, so that I had to ask her twice to speak up. But once she found her footing, something shifted. She told her story the way people tell the truth, not perfectly, not dramatically, but with the kind of detail and consistency that comes from living through something rather than rehearsing it. She remembered specific conversations. She remembered specific dates. She remembered exactly what Gerald had said to her at the conference table. She repeated it quietly, and the jury heard it. Marcus Cole's cross-examination of Patricia was the most sustained piece of legal pressure I had witnessed in several years. He questioned every decision she had made in the 7 years before Gerald arrived. He raised a business loan she had defaulted on in her early years. Paid off, long resolved, but resurrected now to suggest a pattern of financial instability. He walked her through every provision of the partnership agreement line by line, asking her repeatedly whether she had read each section before signing, whether she had sought independent legal counsel, whether she had asked for clarification on specific terms. And when Patricia stumbled slightly on a date, confusing the 15th of one month with the 22nd of another, Marcus paused for 5 full seconds and said, "So you're not certain?" Patricia said, "I'm certain about what he did to me." Marcus said, "What you believe he did to you." Patricia said nothing after that. She didn't need to. I watched the jury that afternoon more carefully than usual. I watched the way they held themselves, the direction their eyes moved, what they wrote down and what they didn't. By the time court adjourned at the end of day 3, Gerald Ashworth was sitting at the defense table with his arms folded and his chin slightly lifted, the body language of a man who believes he is going to win. And I want to be honest with you. Based on what I had seen so far, that belief was not entirely without foundation. Day 4 changed everything. Before the jury was brought in that morning, Renee Voss stood and told the court she had a matter she needed to raise. She had received, late the prior evening, a document produced by a third-party financial institution in response to a subpoena that had been outstanding for 3 weeks. She wanted to move to admit it as a late exhibit. She acknowledged the timing was imperfect. She explained the delay was on the institution's end, not the prosecution's. Marcus Cole was on his feet before she finished her second sentence. His objection was loud and layered. He argued that late production of evidence in a criminal trial was not a technicality. It was a violation of his client's right to prepare an adequate defense. He argued that he had not had time to review the document, that the chain of custody was unverified, and that admitting it under these circumstances would constitute reversible error. He argued for 22 minutes, and at several points he turned partially toward the gallery in a way that told me he was not just speaking to me, he was performing. I let him finish. Then I said, "I will review the document during the morning recess. Both parties will have full access in the interim. We reconvene at 11. Marcus said, "Your Honor, I must strongly emphasize that the defense considers the introduction of this document at this stage to be fundamentally," I said, "I heard you, Counselor, 11 o'clock. He sat down. He uncrossed and recrossed his legs, and the look on his face was not the look of a man who accepts a ruling. It was the look of a man filing something away. During the recess, I reviewed the document carefully. It was a record from a secondary holding account, an account that Dr. Bro had referenced briefly in his testimony as a probable repository for diverted funds, but had not been able to fully trace because the originating institution had been slow to respond. What the document showed was this. Gerald Ashworth had opened that account 4 days before he signed the partnership agreement with Patricia Huang. Not days after, not weeks after, before. He had established the financial infrastructure to drain the business before he had ever shaken her hand, before he had ever sat across from her and told her that Peach and Pepper was exactly the kind of operation he was looking for. This was not a man who had gotten greedy after the fact. This was a man who had arrived with a plan. When court reconvened at 11, I admitted the exhibit. Marcus objected again immediately, this time more sharply than before. He said I was allowing procedurally tainted evidence to infect an otherwise viable defense. He said the jury would inevitably give the document more weight than it deserved because of its dramatic last-minute appearance. He said that my ruling would form the centerpiece of his appeal. I said, "You are welcome to raise whatever issues you deem appropriate in an appellate proceeding, counselor. The exhibit is admitted. Let's bring in the jury." And that was the moment. That was when Marcus Del Rey Cole decided, apparently, that he was done with the ordinary mechanics of objection and argument. He squared his shoulders. He turned to face me fully, not with the posture of an attorney addressing the bench, but with the posture of a man who has decided that the rules in the room no longer apply to him in the way they apply to everyone else. He smoothed the front of his jacket, he looked me in the eye, and he said in a clear and measured voice, "Your Honor, with all due respect, you are powerless to stop what's already been set in motion. My client will walk out of this courtroom regardless of what you admit or exclude. The outcome of this trial is already written." Total silence. Patricia Huang's hand came up slowly to cover her mouth. Renee Voss turned in her chair and looked at Marcus with an expression I can only describe as horrified stillness. The bailiff near the rear door straightened without being told to. 3 members of the gallery stopped breathing visibly. Even Gerald Ashworth sat up straighter, as if his own attorney had said something that surprised even him. I sat completely still. I let the silence hold for 10 seconds. Then I picked up my pen and I wrote on my notepad. I set the pen down. I looked at Marcus. I said, "Counselor, I want to be certain the record captures exactly what you just said." I asked the court reporter to read it back. She did, word for word. I watched Marcus Cole's face as she read. The composure was still there, but something behind it was shifting. A recalculation was happening. He had said something he could not unsay in front of witnesses on the record, and he was now, for what I suspected was a rare moment in his career, uncertain about what came next. I said, "You've told me in open court that the outcome of this trial is already written. I need you to explain what that means, because that sentence, as stated, does not describe confidence in a legal argument. It describes foreknowledge of an outcome. It implies that something has occurred outside this courtroom that has predetermined what happens inside it. If that is what you are telling me, I need you to say so plainly right now on the record. And if that is not what you meant, then I need you to explain what you did mean, because what you said carries the implication of jury tampering, judicial interference, or some other form of corruption directed at the administration of justice in my courtroom. So tell me, counselor, what did you mean?" Marcus Cole opened his mouth, closed it. His jaw moved slightly, as though forming words that hadn't committed to coming out yet. I said, "Take your time." He said, "Your Honor, I misspoke. The statement was rhetorical. I was expressing confidence in my client's position, and I chose my words poorly. I apologize to the court." I said, "I am not interested in an apology at this moment. I am interested in what you know." I called an immediate recess and cleared the courtroom. What happened in the next 45 minutes was the result of an investigation I had not been aware was happening, a quiet, parallel inquiry that the State Attorney General's office and the court's own Administrative Oversight Division had been conducting for several weeks, triggered by an anonymous tip about potential jury interference in a high-profile fraud case that fit the description of this trial with uncomfortable precision. Gerald Ashworth had made a payment of $30,000 to a man named Dennis Pell. Dennis Pell was a private jury consultant, not retained officially by the defense, not disclosed to the court, not operating through any legitimate channel, who had been conducting unauthorized research into the personal backgrounds, financial situations, and psychological profiles of specific seated jurors. He had identified 3 jurors he believed could be reached through indirect social pressure. He had not made direct contact, but the infrastructure for what came next had been quietly assembled. Marcus Cole had not arranged this payment, but the investigation strongly indicated he knew about it, and what he had said in my courtroom, that the outcome was already written, that my rulings would not matter, was not bravado. It was a slip. It was a man who believed the game had already been decided, telling the referee that the whistle didn't matter anymore. When I returned to the bench, I declared a mistrial. I dismissed the jury with a personal statement of apology and deep respect for their service and for what had been attempted against them. I immediately referred the jury interference matter to the State Attorney General for formal investigation and prosecution. I referred Marcus Cole's conduct to the State Bar Association's disciplinary committee and flagged the matter as urgent. And I revoked Gerald Ashworth's bail on the grounds that he represented a demonstrated, active, and documented risk of obstructing the administration of justice. The bailiffs came forward. Gerald Ashworth looked at his attorney. Marcus Cole was staring at the bench. He did not look back. Gerald stood slowly, and they cuffed him at the wrists, and they walked him toward the side door, and the sound of his footsteps crossing that floor is something I still remember. Marcus Cole stood at the defense table and watched it happen. His jacket was still perfect. His posture was still controlled, but the theater was completely gone. He looked like a man standing in the ruins of something he had been certain was solid. The retrial was scheduled 5 months later. Marcus Cole did not participate. He had been suspended from the practice of law pending the outcome of the Bar Association's formal ethics investigation. A finding was issued 7 months after the mistrial, concluding that Cole had made a statement in open court that reflected foreknowledge of an improper effort to interfere with jury deliberations and had failed in his ethical obligation as an officer of the court to report that knowledge. His license was suspended for 18 months. He challenged the finding through the bar's internal appeals process. He lost. The new defense attorney at the retrial was a quieter man. He made reasonable arguments. He was thorough and professional. It did not matter. The evidence was overwhelming, and it was now supplemented by everything the State Attorney General's office had uncovered about the interference attempt, which painted a picture of a defendant who had not only defrauded Patricia Huang, but had then tried to buy his way out of accountability for it. The jury deliberated for less than 4 hours. Gerald Ashworth was convicted on all counts. He was sentenced to 6 years in state prison and ordered to pay full restitution, including the original $46,000, documented lost business revenue, and all legal fees Patricia had incurred across both proceedings. Dennis Pell pleaded guilty to 1 count of unlawful juror contact and received a suspended sentence, 5 years of supervised probation, and the permanent revocation of his professional certification. Patricia Huang went back to Ellendale. She lost 2 venue contracts during the legal proceedings. The uncertainty had made clients nervous, and they had moved on. She kept her core employees, all 6 of them, because she told them the truth about what was happening, and they chose to stay. She kept cooking. She kept showing up. Within a year and a half of the verdict, she had signed a new contract with a regional conference center and hired 2 additional staff members. The restitution payments arrived on schedule, dispersed from Gerald's seized assets. I was told by someone who knew her that when the first payment cleared, Patricia sat in her car in a parking lot and cried for 20 minutes. Not because money fixed what had been taken, but because someone had seen what happened and had said so out loud in a room full of people, officially on the record. That is what courts exist to do. Not to make people rich, not to ruin people for sport, not to perform justice as theater while actual power operates backstage. Courts exist to see clearly, to find the truth underneath all the noise and performance and calculated manipulation, and to say, in plain language, in front of everyone, this is what happened, this is what it means, and this is what follows from it. Powerless. I thought about that word for a long time after the case closed. I understood why Marcus Cole had said it. He had believed, with genuine confidence, that money and strategy had already done the work before I ever picked up my gavel. He had believed that the right payment to the right consultant to the right profile jurors had already tilted the floor of my courtroom in his client's favor. And in that belief, he had made the most fundamental error a brilliant person can make. He had mistaken his own intelligence for the structure of reality. The law is not a performance. It is not a product. It cannot be purchased in advance like a reserved seat. It is a slow, careful, sometimes infuriating process that does not move at the speed of money or confidence or a well-tailored closing argument, but it moves. And when someone stands in front of it and calls it powerless, they are not speaking from strength. They are speaking from the very edge of a ledge they cannot see beneath them. I have watched that ledge swallow arrogance before, and I have no doubt I will watch it again. If you want to hear about another case that walked into my courtroom wearing certainty and walked out wearing something else entirely, stay right here, because the next story might surprise you even more than this one did.